My name's Julie Wirt. I'm an attorney at Williamson, Freeburg & Jones. I've been there for 5 years. I handle a lot of matters, mostly domestic and criminal, but I do see a lot of unemployment compensation. And we thought that was a good topic for today because a lot of us here either have businesses or you know someone who's filed for unemployment compensation. It's something that it affects a lot of people, so we thought we'd go through and talk about the things that occur at a hearing and how you can become eligible for unemployment compensation and how an employer can kind of protect themselves against claims of unemployment compensation when an employee does some type of misconduct.
My name is Shelby Hostetter. I'm also an attorney at Williamson, Freeburg & Jones. My practice area is estate administration and corporate work, and also unemployment compensation. We represent employers and employees, and as Julie said, we'll try to keep it light and not bore you to tears, but there's some interesting things about unemployment compensation, and it does affect a lot of us, and most all of us are paying in for unemployment compensation. So at least we should know a little bit about it.
As far as the history goes, unemployment compensation insurance, the program was initially started in Wisconsin in 1932 during the Great Depression. After that, the federal government enacted legislation establishing the program. PA established our law in 1936, and we're actually one of only 3 states who pays for unemployment compensation from employees. All the rest of the states use employer payroll taxes to fund it. So we are.
To be eligible for unemployment compensation, you obviously have to file a claim when you're unemployed. Just because you're out of work doesn't mean you will necessarily be eligible for unemployment compensation. There is a myriad of reasons why you would be eligible or ineligible. We obviously can't touch on all of them, but we will go through some of the specifics that make you eligible and ineligible. Okay, so the first thing to claim benefits, you have to earn enough money during your base year, and the Unemployment Compensation Board qualifies what base year is. It's the first 4 quarters of the last 5 completed quarters at the time your claim is filed. If you know what that means, feel free to explain it to all of us. But they basically calculate how much money you've made and tell you whether you're ineligible or not. Money made during the base year determines your collection and the amount. So how much you've made determines the amount that you're going to get from unemployment compensation. Additionally, you have to be working at a job that's covered by Pennsylvania's unemployment compensation law. You also have to be let go or not have a job as a reason of non-fault. So it can't be something that's your fault, the reason you're not employed. Some examples of non-fault includes cutbacks, if you've been laid off, seasonal work. If you've been fired or you quit, you're likely ineligible. Again, there's very specifics with firing and quitting, and we'll get into some of that. Additionally, you must be able and ready to return to work. So you can't be disabled, things like that.
The 2 main things that I see why people are ineligible is because they voluntarily quit. If you quit work without a necessitous and compelling reason, which is defined in the law, you're not able to get unemployment compensation. Also, if you're discharged for willful misconduct, that is another thing that will make you ineligible. If you're on strike, or as Shelby said, you're disabled, that means you're not able or available to work, so you shouldn't get unemployment compensation. If you're not physically located in the United States, you can't get unemployment compensation. You also have to actively look for employment. If you're not actively looking for employment, they can make you ineligible. If you're offered a job and you fail to take it, that can also make you ineligible. Like I said, I'm going to focus on willful misconduct. There are ways that we can address this and employers can protect themselves against claims for unemployment compensation because an employee acted wrong. If you withhold facts or give false information to receive increased benefits, they're going to cut you off. If you're self-employed, you're not allowed to receive unemployment compensation too, and they'll watch this closely. So if someone leaves work and they start their own business, but they're trying to collect unemployment compensation, it's not going to work because they're not funding you so you can start your own business. If you're incarcerated, or you, like I said, fail to participate in the required employment services, and like I said, traveling outside the country, you want to contact the UC Service Center to make sure that you're not ineligible.
And if you are unemployed and can travel outside the country, let us know what you're doing so we can maybe do that too. Unemployment compensation, again, is governed by the Unemployment Compensation Law, which Julie mentioned, our state enacted in 1936. And the statute, for any of you that care, is 43 PS section 751 through 918.
Like I said, one of the biggest reasons for ineligibility is willful misconduct. That's defined in the statute. It's a wanton or willful disregard of the employer's interests, a deliberate violation of work rules, a disregard of the employer's reasonable standards of behavior or performance, negligence of a degree that manifests evil intent or other high level of culpability. One of the reasons we highlighted work rules is this is a great way to set up your case if you find yourself the subject of an unemployment compensation claim. If you have clear work rules and they're known by your employees and one of them breaks the rule, you can challenge their receipt of unemployment compensation.
And just a quick note, they refer to before the unemployment compensation law refers a lot to uncodified sections. So section 402E is the same thing as 43 PS 802E, but the numbers are different. So if you ever get something, whether you're an employee and you get a claim and it says you're eligible or ineligible under 402E, or you're an employer, those numbers don't match up, so it could be a little bit confusing. Okay, so some of the methods for proving willful misconduct if you're an employer and you don't want to be paying unemployment compensation for an employee that you fired for a reason, is introduction of employee handbook with written policies. This is probably the biggest help for employers out there when you go to a hearing. If there's a written policy that says you can't be late more than 3 times and you have an employee that's late 5 times, it's pretty crystal clear. Again, with that employee handbook, it's also very important to get an employee sign an acknowledgement verifying that they've read the policies and then they understand and accept them. Then you can never get the response from the employee that says, I didn't know that work rule existed. Employee evaluation forms. So again, keeping track of how your employees are doing, if they're performing well, if they have glowing reports and then all of a sudden they're fired, that's sort of a red flag for unemployment compensation on the employer end that, well, why is this person let go? Similarly, on the other side, if they have, warnings and things like that, then that's something to look out for. Again, that just goes to warnings of policy. So Joe Smith comes into work late and you tell him, you can't be late again. Then they know, they're aware of the rule, even if they claim that they're not. And even if it's not a written policy, you can say you can't be late again, we're going to have to let you go. So, communicating with your employees' responsibilities. Detailing job duties, making sure the employee knows what to expect. And also documenting your termination process, just basically to, again, when you go to the hearing, you have things documented, why they were let go, when they were let go, if they've had prior warnings. So really important to have things documented. And also supporting case law, which we probably can't get into today, but one of the important things of having an attorney, a lot of these situations, believe it or not, are common situations that occur. We see them in a lot of cases: habitual tardiness, crimes, violation of work policies. So a lot of things are reoccurring that there's good case law to support you in pretty many of the situations that arise as an employer. The procedural process. So the administrative process, as we like to call it, can be a little complicated, and as far as you work up your way up the ladder, they basically want you to exhaust your administrative remedies to make sure that the employee and the employer are heard. So the process starts by a claim is filed by the employee. They're then known as the claimant. And then once the claim is filed, the service center, the Unemployment Compensation Service Center, they're all over, They will issue what's called the notice of determination. For layman's terms, it's a decision, usually given after a discussion with the employee and the employer. If either party is unhappy with that decision, they can appeal it, and they get a hearing in front of the unemployment compensation referee. We have that starred because that's basically where we get involved and where most of our things take place as far as attorneys go on this level. After the referee issues the result, either party has the right to appeal to the Unemployment Compensation Board of Review. Board of Review will issue a decision. And finally, either party has the right to appeal to the Pennsylvania Commonwealth Court, and that's your last right of appeal. After that, you can appeal to the Supreme Court of Pennsylvania, but no one has an actual right to appeal there. The Supreme Court can decide whether they want to hear the case or not.
Like Shelby said, we usually get involved right before the hearing. So at that point, the service center has issued a determination. So they've listened to written items from the employer, things that the employee may have submitted, and they make a determination. Now, when you go to the referee hearing, it's a whole new hearing. So you can introduce all the evidence you want. When you show up, and I do a lot of them at the Career Link in Pottsville, that's where they take place. You go in and they give you a file, and you look through all the information that's been submitted so far. And the important thing about doing that is you can look through and you can get documents taken out. Because the last thing you want is a statement from someone that says something you can't anticipate, that then they show up as a witness, and they don't show up as a witness. So now you have this wild statement that can affect your case. So it's important to go through it and get that information out at the hearing. So when you go into the hearing, you'll sit there around a table, and the referee will be behind a desk, and he tape records it because there's a transcript created. The burden of proof on willful misconduct cases is initially with the employer. So the employer must show that there was a handbook policy, that the employee did some type of misconduct, and how that affected the employer. After the employer has shown misconduct, the burden then goes to the employee to prove that their actions did not constitute willful misconduct. Like I said, if the employee's actions are found to be justifiable or reasonable, it won't be considered willful misconduct, and they'll be approved for benefits. One of the most important things is to actually show up at the hearing. There are a lot of cases where you'll show up, you have no idea if the other side's going to show up at all. Sometimes they do, sometimes they don't. Even if I represent an employer and the employee doesn't show up, it's still important to have a record established showing that what the employee did wrong and that they were terminated, and to get out any statements they may have made in writing to the service center. So just showing up is the biggest thing. There must be adequate witnesses. Another reason, you may have an employee who does something egregious, but if you don't have a witness who saw it or someone who documented it, who actually was there when it happened, they can't listen to that. The referee will exclude it because it will be hearsay. It'll be, the secretary, she saw this woman come in late 10 times and she was dressed horribly, and it's very unprofessional. But if the secretary is not there to tell you what she saw, that employee could get unemployment compensation benefits. Like I said, it's the person who observed the conduct, the person who disciplined the employee, and someone who's familiar with the handbook and the policies. Okay, so like I said, for an example, if someone screams profanities at a coworker, it's best to have that coworker there to testify as to what happened. Again, also, if an employee witnessed a drug deal at the office, you want that person there to testify about it. Not, if someone came to me and said that they saw this drug deal, that's not going to fly. It's going to be considered hearsay, and they can exclude it. So, another thing, if there's criminal conduct involved, like I said, a drug deal or something like that, you may want to have the police officer there who wrote up the incident or made the chart or filed the charges. They would be a great witness to have to show that this was a serious event and we're continuing to prosecute this person.
Just to piggyback off what Julie said, it's important, mostly critical, to expand the record at the hearing. When we say that, make sure you have everything and everyone there, whether you're the employee or the employer, because every time you move that chain of the appeal process, you get further away from the fact finder, and we say fact finder. So the referee is the one that's going to basically determine your facts. Most of the time, the board, which is the Unemployment Compensation Board of Review, will accept the facts of the referee. So, you have 1, maybe 2 chances to plead your case. So always show up and always expand the record to the best of your ability. Okay, so we had discussed willful misconduct and, to basically say that I didn't commit willful misconduct, you have to show good cause. So what are some examples of good cause where even though I violated a work rule, I had a good reason for doing it? Again, these are some examples of real life cases. School employee filing charges against a student. The employer couldn't prove that, that action was against the employer's interests or fell below the standards that an employee could expect. Notifying an individual in a perceived position of power that their actions would not result in adverse disciplinary actions. Hey, Julia, I'm going to be late tomorrow. Don't worry, it's fine with Jim Crossan. It's really not fine with Jim Crossan, but I thought it was okay. So that would be a good reason. Claimants believe she was on leave pursuant to the Family Medical Leave Act. So she's thinking she doesn't have to call in, say where she is. Again, that was good cause.
We're going to run through some hypotheticals here to give you an idea of what's considered willful misconduct and what's not considered willful misconduct, because it changes in a lot of circumstances. So the first scenario, if we have a security guard who's sleeping on the job, it's his first time offense, and the employee handbook doesn't say anything, there is no employee handbook, do you think that that is considered willful misconduct? Anyone?
Oh, yeah.
Yes, it is, because it's common sense that a security guard would need to be aware of what they're doing. So that's kind of a no-brainer. In the next scenario,
it's a softball where they get harder as they go on. Don't worry.
If there's a manager or someone in power who's requesting personal loans from a subordinate, again, there's no employee handbook, and I don't know that one could anticipate a rule stopping that. Any idea whether a manager requesting personal loans from a subordinate would be willful misconduct? Jim? It was. I guess the loans that this person was requesting were very large, they were substantial, so it was creating some problems in the workplace. The third scenario. A claimant's hired, he's told, you need a driver's license to perform this job. He has a driver's license, but is temporarily suspended because he has parking tickets. He was fired because he didn't have the license, but later, he gets the license returned to him. Now, let's say there's no employee handbook that details the job description. This would have been a great case where if you had to detail, if you detailed a job description including that, maybe you would have been saved. But in this case, the man was denied unemployment compensation because he knew when he took the job, and they told him they had adequate witnesses there who testified about it, he had to have a license, and if he didn't, he got fired.
Okay, scenario 4, failing a drug test. First time offense, employee handbook. However, the employee acknowledgement, so that paper that we talked about before saying that I understand the policies, I accept them, was signed after the claimant was forced to take the drug test. What do we think? Willful misconduct or not? Not willful misconduct? Could go either way. This one was willful misconduct because policy is in place. I think that because the employee was forced to take the drug test before she saw the employee handbook, I think that would not constitute willful misconduct. Scenario 5, corrections officer who commits welfare fraud.
And this is a case where you have a corrections officer in his job, there are maybe no issues at all,
Right.
No concerns with his conduct, but outside
Right, this is
of his
outside
job,
of work.
he commits a crime. Welfare fraud. Obviously, this is a trust issue. Any ideas? Committing a crime outside of work that doesn't affect, well, supposedly doesn't affect your job. Yes, no. In this case, they determined that it was willful misconduct because this corrections officer handled inmates' money. So they said if there was an issue with trust, he could be terminated. It was considered willful misconduct.
6, this is a good one. Refusal of an employee to take a lunch break. So they just want to work so bad that they don't want to take a lunch break. It's kind of like Julie and I.
Yeah.
That's what happens to us all the time. So, okay, doesn't take lunch. Employer says, you have to take lunch. Willful misconduct? Anybody? Well, yeah, the willful misconduct, and the employee was denied unemployment compensation benefits for not taking a lunch break. So don't work too hard. That's the point. That's what we're getting at here.
One of the things we talked about that's really important to have is an employee handbook. And I'm going to pitch here a little for lawyers. It's good to have a lawyer write it up because you want to avoid making a contract with an employee who's an at-will employee. So you need to be careful about what your employee handbook says. Also, especially with like drug testing policies, you have to be careful about how that's written. But the one main thing you want to do is if you have a handbook, you want it to clearly state what the policies are. You want it to state what a person's job description is and what's expected of them. And you want to have them acknowledge it so that you can walk that into an unemployment comp hearing and say, you signed this, you acknowledge that you had read it.
Yeah, again, just to go off what Julie said, it's extremely helpful to prove those violation of written policies, to have an employee handbook, and to make sure that the employee understands, what they're responsible for.
So that's it. If anyone has any questions, we can take some questions now. It's a tricky area. Not a lot of attorneys practice in it actually because they come and go. I'll have 5 cases at once and then I'll go for 2 months and I won't even see one. So, if you have any questions, let us know. You can also email us or call us. Good.
Gail and I sit on our local library, and I don't know, maybe 15, 20 years ago, we had a really, really nasty case of unemployment. We decided not to contest the unemployment, but there was a lot of hard feelings, and the employee then turned around and sued based on one of the protected qualifications for, I think it was age discrimination maybe or something like that. So it opened the door to a whole lot of litigation that we really didn't have time or money for. And then in the subsequent unemployment case, of course, the board at the time was very concerned, not to repeat the errors of the first time. So to sort of smooth things over, they decided not to contest the unemployment. But the lawyer that was helping us through this said, maybe that's not a good idea because in his experience, if a lawsuit then did come out of it, one of the claims that the lawyer made that was representing this person was that, look, you didn't contest the unemployment. In other words, it's almost like an admission of guilt on your part. Is that valid? I mean, can that happen?
Can you use that decision in this later stage?
No, because that scenario happens a lot. You can mention it, but I don't think that it's very relevant because they're 2 separate proceedings. You had talked about not challenging the unemployment. And one of the reasons to do that, obviously, is because if this person's then collecting unemployment, maybe they're less likely to sue you for something else because they're already getting money. The other side of that, though, is sometimes it's better to go through with the hearing, unemployment comp hearing, only because it's a great way to get evidence on a case for a future case. I've had the same scenario. I represented an employer. They're now involved in a discrimination case, but I got all the discovery I needed in an unemployment comp hearing. The case was all laid out for me. So that was one of the reasons we did that, was because we knew that the employee would have to come in and answer a lot of questions and basically be stuck with that testimony as to what they said.
I don't know how much evidence you can use from an unemployment comp hearing in a later civil claim.
That's why I said it's more like a discovery process.
Right.
Because then I know, who I need to talk to, who are my witnesses, what am I looking at? It's a way to feel the case out before it goes any further. Anything else?
Okay, so they're not seasonal employees, but they work during certain times of the year. And they don't get paid hourly, they get paid how can an employee who left, okay, go to another job, the job falls through, they come back, we have no work for them, and then they file against us? How can they do that?
It depends upon where you've worked and how you've worked, because they look at the 4 quarters preceding the unemployment filing. So I've also had a case like that too. A guy leaves a job for a better job. At that job, he's there 2 days, takes a drug test, fails, he gets fired. Now when he files for unemployment, it's going to go back against the first employer because that's where the wages were made.
I mean, we're talking maybe 3 months.
Yeah.
And the bridge wasn't burned. Like, he left, we knew he left, the job fell through, he came back, he never showed up, we found one thing for him, and then he burned us again. Well, now that bridge is burned. But then now we found out he filed.
Yeah. Yeah, there's a certain look back, there's a certain period of time that they'll go back, and if it's not, if the time frame doesn't fit under the current employer, it'll go back to the previous one.
Plus, if you voluntarily quit, that's another thing we touched on, but we didn't really get into it. If you voluntarily quit without a necessitous and compelling reason, and there's a definition for what that means, you should be ineligible for unemployment compensation. I can't just quit my job at Williamson, Friedberg and Jones, go work down the street, and say, oh yeah, I want to collect from Williamson, Friedberg and Jones.
There's a scenario too where a person has a full-time job and then also has a part-time job at another company.
Mm-hmm.
They get laid off from their full-time position and they file on unemployment compensation. Is it true then that the company where they work part-time has to pay part of that unemployment claim even though that job is still in place?
It depends. There's a definition of unemployed and employed, and you cannot be working full time. JT should know about this one too. You can't be working full time, but part time wages will qualify. Won't prohibit you from collecting unemployment compensation. And as Julie was mentioning, it depends on where you've made the most wages.
But why would the second company have to pay part of the unemployment compensation when that person is still employed in their part-time position? They haven't been laid off from their part-time position at the second company. So that part I don't understand. Why would they have to pay a portion of the unemployment?
Right. I would think that the full-time employer wouldn't be responsible for if they got laid off. Do you know the answer to that?
The answer here, and also maybe on that one too, is if you're in that situation, it may come back, but you could then probably apply for what's called relief from charges, so that it doesn't affect your risk and claim rate. It comes out, but yet it's a no fault on your part. So there's a relief from charges process that comes about in those situations, particularly in the other situation here where it was assessed against the prior employer, even though that employee left on willingly. And the relief from charges process is basically a forgiveness from that. Yes, it's coming out of your account, but we're not going to have that affect your rates because you employed that person, they left willingly, and they didn't have a long enough time at job 2 to qualify them for unemployment under that job. So it's a relief from charges process, which is a supplemental proceeding, a little bit outside what we can do here, or else we'd probably be here through lunch. There's not enough food, but.
No, there's not enough food for that.
Okay.
Yeah.
You're employed and your employer, like they don't have your job anymore. They come to you and say, we're not doing this job anymore, but we can give you this job. And you don't want to do it and you leave, can you collect unemployment?
That's a tricky one. I think it depends because I think as we mentioned, if there's other suitable work, again, it would depend on the specific facts of the situation. But if you're, referred for another position and you decline it, you most likely will be ineligible. But depending, there could be some intangibles if the position is much worse. So
Yeah, they look at,
to answer your question, it depends.
Yeah. Do you have good cause not to take that job? That's really what they look at.
At a situation similar to the one you were talking about, a couple of years ago when the gas prices were going sky high compared to where they are now, and it was a relatively minimal part-time job, the commissions weren't working, we actually were able to get comp in large part because we could prove this person wasn't making money.
Right.
Between the gas they were having to expend to drive an extremely long distance to and from work in the minimal hours, and a lot of times they were only put on shift for 2 hours. We actually got them comp under the necessitous and compelling, because at the end of the day, when you started paying all this fuel out and an inefficient